Courtroom script and legal commentary. State of New Mexico v. Isaac Apodaca. Location: First Judicial District Court, Santa Fe, New Mexico. Charges: first-degree willful and deliberate murder, conspiracy to commit first-degree murder. The victim: Grace Jennings, 21 years old. The core issue: accomplice liability via text messaging. Can words alone make you a murderer? Overview of the final day. Day 6 of the Bloody Sword murder trial brought an end to one of the most chilling legal theories tested in a New Mexico courtroom. Isaac Apodaca never held the 3-foot sword that brutally ended the life of Grace Jennings in a Santa Fe garage. The physical killer, his girlfriend Kiara McCulley, had already pleaded guilty. Instead, the prosecution successfully argued that Apodaca was the architect of the crime using years of psychological manipulation, toxic text messages, and coordination to steer McCulley toward the assassination. And the transcript. Day 6 courtroom drama. Our 9 a.m. the charge conference, jury excluded. The court judge: let the record reflect the jury is not present. We are finalizing the instructions. Mr. Nair, does the defense wish to include the lesser option of voluntary manslaughter on count 1? Defense counsel: Mr. Nair: no, Your Honor. After consulting with my client, we are withdrawing voluntary manslaughter. We are gambling on an all-or-nothing strategy. Either he is guilty of first-degree murder as an accomplice, or he is completely innocent. The court: Mr. Apodaca, please stand. You have the constitutional right to testify in your own defense. Have you made a final decision? Defendant Isaac Apodaca: I will not be taking the stand, Your Honor. Legal analyst: the defense pulling manslaughter is a massive tactical gamble. They are betting that the jury will find convicting a man of first-degree murder solely based on text messages too high a hurdle to clear. By keeping it all or nothing, they hope for a total acquittal. Our 10:45 a.m. prosecution closing argument. Prosecution: Ms. Murphy. Ladies and gentlemen of the jury, the defense wants you to look at Isaac Apodaca's hands and say, look, there is no blood on them. They want you to believe that because he wasn't standing in that garage swinging a 3-foot blade, he is innocent. But look at the screen. Look at his digital fingerprints. The prosecution projects thousands of text messages onto the presentation board detailing a countdown from 6 and explicit instructions on how to target his ex-girlfriend. Prosecution: he didn't swing the sword because he didn't have to. He spent years fueling Kiara McCulley's resentment. He looked up how to dispose of a body on Google. He was the architect. He built this murder with words. Our 1:30 p.m. defense closing argument. Defense: Mr. Nair. Suspicion, ladies and gentlemen, is not proof. The state has shown you a mountain of ugly, toxic, and horrific text messages. They have proven my client is a terrible partner. They have proven he said disgusting things. But being a bad person via text message does not make you a first-degree murderer. Bangs the defense podium. Defense: Kiara McCulley is the one who entered that garage. She is the one who harbored the rage. She is the one who physically took the life of Grace Jennings. Nothing physical, no DNA, no footprints, nothing puts Isaac Apodaca in that garage. Do not let your anger at his text messages substitute for a total lack of physical evidence. Our 3 p.m. deliberations in the dark. Anchor: we have a highly unprecedented development here at the Santa Fe courthouse. A massive power outage has struck the grid, plunging the entire building into pitch blackness. However, the jury has refused to halt. We are hearing reports that the 12 jurors are actively deliberating inside their room using the flashlights on their cell phones and emergency lanterns. The verdict and legal commentary. Our 5:30 p.m. the verdict is read. The power remains completely out. The courtroom is eerily lit only by emergency backlights and the glow of phone screens as the jury files back into the box. The court: has the jury reached a verdict? Jury foreperson: we have, Your Honor. The court: the clerk will read the verdicts. Court clerk: on count 1 first-degree willful and deliberate murder, we find the defendant, Isaac Apodaca, guilty. On count 2 conspiracy to commit first-degree murder, we find the defendant guilty. Yen the aftermath and reaction. As the 2 consecutive guilty verdicts cut through the darkened room, Isaac Apodaca sat entirely smug and emotionless. He showed no visible reaction, staring straight ahead as the judge polled each individual juror by name. One by one, 12 voices confirmed the conviction in the shadows. A legal analysis. The precedent set. This case represents a landmark application of accomplice liability and conspiracy in the digital age. Intent. Digital triggers, Google searches plus encouragement. Years of messages equals first-degree accomplice liability. 1. Words as the weapon. The defense heavily relied on the physical absence of Apodaca from the garage. However, New Mexico law allows a defendant to be convicted of first-degree murder if they intentionally encouraged, helped, or caused the crime to be committed. The jury determined that the relentless barrage of text messages directly engineered the psychological framework required for McCulley to strike. 2. The flaw in the defense's gamble. By removing voluntary manslaughter from the verdict options, the defense backed the jury into a corner. Instead of triggering a compromise verdict, the horrific nature of the Google searches, how to dispose of a body, combined with the target list forced the jury to accept the state's timeline of clear, calculated deliberation. Isaac Apodaca faces a mandatory sentence of life imprisonment for first-degree murder with the formal sentencing date set by the court.
Looks like Antonio Leyba was reset for the 22nd at 2:30 in the afternoon.
Okay, I'll update my calendar.
Yeah, the state should have let you know. I apologize. In D101CR 2023-25, with counsel and Mr. Apodaca present, we've been informed that we have verdicts in the case. Is there anything preliminary to taking the verdicts?
Nothing from the state judge.
Nothing for defense, Your Honor.
Okay, thank you. A couple of procedural things, just so that everybody's aware before we get started. I'll ask counsel after we take verdicts if they want the jury polled. And then I'll release the jury. We all stay in the courtroom until the jury is outside past the guard station on the first floor. So we'll be sitting for a while after we take those verdicts. Okay, let's have our jury, and we'll be off the record until they come in.
All rise.
You may be seated in the courtroom, ladies and gentlemen. We are back on the record with the jury, counsel, and Mr. Apodaca all present. Mr. Foreperson, my understanding is the jury has reached verdicts. Is that correct?
Yes, Your Honor.
If you would give the instructions and the verdicts to the bailiff, please. I need to review them, make sure we've got everything back, and then I'll read the verdicts into the record. The court has returned the verdict forms as well as the 22 jury instructions that were sent back to deliberations with the jury. Mr. Apodaca, counsel, would you please rise? In the State of New Mexico versus Isaac Samson Apodaca, cause D101CR 2023-25, we find the defendant guilty of murder in the first degree as charged in count 1, signed by the foreperson, the corresponding not guilty verdict form for count 1, and the two guilty and not guilty verdict forms for, second degree murder have been left unsigned. With respect to count number 2, we find the defendant guilty of conspiracy to commit murder in the first degree as charged in count 2. The corresponding not guilty verdict form is left unsigned. You may be seated.
Thank you.
Do the parties wish the jury to be polled?
Yes, Your Honor.
Yes, Your Honor.
Okay. Ladies and gentlemen, either party has the right under our rules to ask that the jury be polled. So what that means is I'm going to start and ask each of you as to each count if the verdicts that I have received represent your verdict. So I'll start in the back row, and then I'll come around the back row, and Mr. Foreperson, I'll speak to you last. Okay. Juror number one, with respect to count number one, the jury has returned a verdict of guilty. Is this your verdict, and was this your verdict at the time the vote was taken?
Yes.
Juror number two, as to count number one, was this your verdict, and is this your verdict?
Yes.
Juror number three, was this your verdict, and is this your verdict?
Yes.
Juror number four, was this your verdict, and is this your verdict?
Yes.
Juror number five, was this your verdict, and is this your verdict?
Yes.
Juror number six, was this your verdict, and is this your verdict?
Yes.
Juror number seven, was this your verdict, and is this your verdict?
Yes.
Juror number eight, was this your verdict, and is this your verdict?
Yes.
Juror number nine, was this your verdict, and is this your verdict?
Yes.
Juror number 10, was this your verdict, and is this your verdict?
Yes.
Juror number 11, was this your verdict, and is this your verdict?
Yes.
Mr. Foreperson, was this your verdict, and is this your verdict?
Yes.
The jury has been properly polled with respect to count number one. With respect to count number two, the verdict returned by the jury was guilty of conspiracy to commit first-degree murder. Juror number one, was this your verdict, and is this your verdict?
Yes.
Juror number two, was this your verdict, and is this your verdict?
Yes.
Juror number three, was this your verdict, and is this your verdict?
Yes.
Juror number four, was this your verdict, and is this your verdict? Juror number five, was this your verdict, and is this your verdict?
Yes.
Juror number six, was this your verdict, and is this your verdict?
Yes.
Juror number seven, was this your verdict, and is this your verdict? Juror number 8, was this your verdict, and is this your verdict?
Yes.
Juror number 9, was this your verdict, and is this your verdict?
Yes.
Juror number 10, was this your verdict, and is this your verdict?
Yes.
Juror number 11, was this your verdict, and is this your verdict?
Yes.
Mr. Foreperson, was this your verdict, and is this your verdict?
Yes.
The jury has been properly polled with respect to count number 2. Ladies and gentlemen, at this time, having completed and returned verdicts, I'm going to discharge you as the jury in this case. So a couple of quick instructions and I'll let you go. First of all the restrictions that were placed on you at the beginning of the trial are now lifted. You can talk to anyone you want to about the case. You can look up the names or any information about the case. All of those restrictions are lifted. You control all communications. So you can pick and choose if you want to talk to someone about the case and not to. Sometimes the attorneys want to speak to jurors. The way that happens, we have a special way of doing it. They have to notify the clerk of the court downstairs on the first floor. She would get the information and she would contact you and give you their contact information, and then you decide whether or not you want to return the call or the text message or the email. So you control all communications. No one should, none of the attorneys or their staffs or investigators or anybody should, come to your home or your work or anything like that to talk to you. If someone does approach you and you don't want to speak to them, simply let them know. And if anyone persists beyond that point, let me know, and we'll put a stop to it very, very quickly. With respect to your service, since you've sat through an entire trial, I give you the option if you want to be taken out of the larger pool for the rest of your service. All you need to do is let Angel know, and he'll let the jury clerk downstairs know. If you want to remain in the larger pool, you can. You may or may not be called back during your term of service. And if you remain in the pool, you'd be contacted in exactly the same way that you were contacted to be present for jury selection and to come back for the trial. Any questions about any of those issues? Okay. The other thing, I need to make sure you leave your notes with the bailiff. Your notes, along with the notes of the alternates, will all be destroyed. Have you retrieved all of the exhibits? Okay. So that was the other thing I needed to check on. We need to have all the original exhibits back in the court's custody. The last thing I want to talk to you about is this experience. It is not normal for most of us to sit through a trial or a hearing or any kind of a forum where you've heard testimony from the Office of the Medical Investigator. You've seen crime scene photos. You've seen autopsy photos. You've heard the testimony in the courtroom. We've come to know over time that this process can inflict a type of trauma to individuals. So Angel will give you a pamphlet that's been prepared by the Administrative Office of the Court that just discusses that. I've been talking to juries now for over 10 years about this issue because I had a situation where a couple of years after a trial, I ran into, just by happenstance in the community, a former juror, and part of that conversation was how they were still had a problem, were kind of upset, disturbed by their experience. After that conversation, I asked them, what they had done to kind of process the whole experience, and the response I got was, well, nothing. I would suggest to you that you take some time in the next couple of weeks in whatever you normally do in your life to deal with complex emotional situations and things that you've been exposed to, that you take some time and actively process what you've been through. And again, whether that's having a conversation with a friend over a cup of coffee or going for a walk up at Aspen Vista up in the mountains, whatever you normally do, I encourage you to take some time to do this in the next few weeks so that you can kind of put this in context with the other things that have occurred in your life and hopefully help you to heal and move on. Do any of you have any questions for me about any of that? So what we're going to do is I'm going to discharge you in just a moment. Angel will walk you out. The rest of us will remain in the courtroom. Once you're past the guard station at the front of the building, then I'll release everyone else in the courtroom. Last thing I'd like to say on behalf of the court, all of my staff and the parties, we'd like to thank you for your patience. Didn't know we were going to have a power outage today, but thank you for your patience during the trial, your attention, your commitment to the process, and all the work that you've done. I discharge you as the jury for this case. Would all rise while the jury departs.
All rise.
Thank you all. If you go with the bailiff, please. You may be seated in the courtroom, ladies and gentlemen. Are they on? Do you know? We'll set sentencing probably about 30 days out. We'll send you a notice of the hearing and give you ample time to make whatever information you want the court to receive and to review before the hearing. Anything that you send to the court, you need to share with opposing counsel and send a cover letter indicating that you've done that. Okay. Is there anything else before we go off the record in this case from the state? Ms. Murphy?
No, Your Honor, nothing from the state of New Mexico.
On behalf of Mr. Apodaca?
A few issues, Judge. First of all, I just want to inquire of the court, was the jury deliberating, if the jury was deliberating under the power outage, were they adequately supplied with technology and different things?
They had their own lights back there. We provided them lights. They had verdicts. I was informed about not long after the power went out. And so they were sequestered in the back without anyone having an access to them until they were called into the courtroom now.
So they had a generator or something back there?
They were using cell phones and flashlights to light up the jury deliberation room.
Okay. And this is one case, Judge, where I think we'll need a mitigation report from a qualified expert in regards to Mr. Apodaca's history of trauma and various different issues. So I don't know if the court wants a formal motion to continue
Yes.
the 30, or if we,
Yes, we'll give you a date and then we'll need to file a motion.
okay. All right, thank you.
Anything else, counsel?
Nothing for defense. Thank you.
Okay. Mr. Apodaca?
The order for ad seg.
I'm sorry?
The ad seg order.
Oh, yeah. Can we have him removed from SEG?
Yes.
And phone.
I need an order. My administrative assistant, we have a video hearing, so she's back there dealing with that. So I'm not sure she's listening to us to prepare the order, but he'll be released from administrative segregation and his phone privileges are restored.
Okay.
Mr. Apodaca, You've been convicted by a jury of your peers. We're going to set sentencing out for about 35 days. It may be a little bit longer than that based on what your attorney just told me. But at this time, I'm remanding you into the custody of the sheriff of Santa Fe County to be held in safe and secure care until further order of the court. He's in your custody, Sergeant. Do you need to speak to him, counsel,
Yes.
before they take him back?
Yeah.
Sergeant, if you'd give him about 5 minutes in the back before you take him down.
Yes, Your Honor.
Thanks, Judge.
Okay, we're off the record. The rest of us are just going to sit for a few minutes.